Nancy Cavey, National ERISA and Individual Disability Attorney and Social Security Disability Attorney. Welcome to Winning Isn't Easy. Before we get started, the Florida Bar tells me that I have to give you a legal disclaimer. This podcast is not legal advice. Now, I've complied with my bar obligations, but I will tell you that nothing will ever prevent me from giving you an easy-to-understand overview of the disability insurance world, the games that disability carriers play, and what you need to know to get the disability benefits you deserve. So, off we go. As an attorney who does both Social Security disability and ERISA disability work, I get lots of questions about the interaction of these cases. What's the difference between Social Security? What's the difference between that and ERISA? What's the interaction? And these are great topics for discussion because many ERISA disability policies require that you apply for Social Security disability benefits so that the carrier, can reduce your long-term disability benefits by the receipt of your Social Security benefits and that of your children, dependent children. Now, many people will say to me, well, I don't want to apply for Social Security benefits, and I'm not. And I have to say to them, too bad, so sad, because the policy language requires that you apply and that you go through this application process, generally through a hearing. So you may be wondering, well, why should I be listening to this podcast? And the answer is because this all is interrelated and it impacts your rights to your long-term disability case, and obviously impacts your right to Social Security benefits. I want to remind you that in addition to getting Social Security disability benefits, once you have satisfied your 5-month waiting period and have gotten Social Security benefits for 24 months, you become eligible for Medicare. So I don't want you to just kind of dismiss a Social Security claim because of this offset issue. I want you to also consider that there are valuable medical benefits that come with getting Social Security disability benefits. So with that introduction, I'm going to be talking to you about 3 things today. I'm going to be talking to you about the 5 things that the Social Security Administration needs from your treating physician that can make or break your claim and can have an impact on your ERISA disability claim. I'm also going to talk with you in 2 segments about functional capacity evaluations and residual functional capacity forms, and why, in my view, those can be crucial to the success of both your Social Security disability and your ERISA disability claim. Let's take a break before we get started, and when you come back, make sure you have a pad and pencil or pen, because I'm going to be covering a lot of important information that you'll want to share, not only with your spouse and your family members, but with your doctor. Got it?
Filing for Social Security disability, or has your claim been denied already? Either way, you require a copy of your rights to Social Security disability benefits, which will cover everything you need to know about the Social Security disability claims process. Request your free copy of the book at caveylaw.com today.
Welcome back to Winning Isn't Easy. What are the 5 things that the Social Security Administration needs from your treating physician that can make or break your Social Security claim and just might make or break your ERISA disability claim? I'm often asked, well, why can't I just get a letter from my doctor saying that I'm disabled? Well, the reason is they don't really care what your doctor has to say about whether you're disabled or not, because the Social Security Administration uses a 5-step sequential evaluation to determine your entitlement to benefits. They ask, do you have a medical impairment? Is this impairment sort of temporary in nature, or is it one that will keep you out of work for at least a year or potentially result in your death? Do you meet a medical listing? Can you go back to your past relevant work, which is the lightest work and simplest work you did in the 15 years before you became disabled? And that's step 5. Can you do other work in the mythical, hypothetical, not real world national economy that you wouldn't want to do, that doesn't pay a living wage in view of your age, education, your transferable skills, and your restrictions and limitations? Now, I find that many medical records do not address a person's restrictions and limitations. And we supplement that in what's called a residual functional capacity form, which I'll talk about in later parts of this podcast or video. The Social Security Administration does recognize that your doctor can provide a longitudinal history of your medically determinable impairment, which can be important because that's step number one. And then the doctor can comment on how long your medical condition is expected to last. The doctor can comment on how your medical condition impacts your ability to function. They can explain the nature, severity, extent, and duration of your impairment that cannot necessarily be gleaned from the medical records. They can comment, again, on your functionality, not only in terms of work, but activities of daily living. They can comment on treatment and the side effects of medication. And they can comment on things like pace, off-task issues, absenteeism. This information is rarely found in medical records and is, quite frankly, never really asked for appropriately in the attending physician statement forms that the disability carrier is going to ask you have your doctor complete. What I find is that the best way to get at this is to have your doctor complete what's called a residual functional capacity form for your applicable disabling condition or conditions. Now, we Social Security lawyers have developed about 50 different residual functional capacity forms based on a wide range of medical conditions, specific medical conditions. There can be Ehlers-Danlos, fibromyalgia, heart disease, back conditions, you name it. And there's a generic ones that we can use generically for physical conditions and generically for psychological or psychiatric conditions. All this is important because Social Security is going to determine the severity of your impairment, your ability to go back to the lightest job you held in the 15 years before you became disabled, and your capacity to do other work. I will often, when I'm representing a person in both their Social Security and their ERISA claims, have my client give their doctor a residual functional capacity form or forms for the right medical conditions. And I attach those to the attending physician statement form because I want the doctor to answer the right questions. You also need to understand that the Social Security Administration is going to want to see what's in that long-term disability file. And if your doctor has completed a generic APS form that's not necessarily favorable to you, we've got the peer review doctors rendering opinions, we want to be able to rebut this with or supplement it with a residual functional capacity form. So this information is important in my view in the context of both a ERISA disability claim and a Social Security claim. That's why I take a team approach to developing these issues and getting this information about a person's functional restrictions and limitations. We want the evidence, and we want the evidence to be consistent. Okay? Now, I'm often asked, does the Social Security Administration use an average man test in determining entitlement to benefits? You may have heard the term average man used in legal TV shows, and you may be wondering if the Social Security Administration uses an average man test to determine your entitlement to benefits. And the answer is no. There's no one test to determine whether a person has a disabling impairment, can return to the lightest job they held in the 15 years before they became disabled, or can return to other work in the mythical, not real world national economy. The Social Security Administration, unlike many ERISA disability carriers, recognize that you are a unique individual and that your experience of a medical condition is different from anybody else's. In other words, your symptoms and what you can do in light of those symptoms and restrictions can be different from someone else's experience. In other words, you might have a heart condition that makes you capable of only doing sedentary work in a low stress environment. I might be able to do that while you couldn't. Another person with that same heart condition might have shortness of breath without exertion, with palpitations, side effects, and anxiety. That person probably couldn't do sedentary work on a sustained basis, but I might be able to. You might have a low tolerance for pain. Well, somebody else can soldier on despite their pain. So your experience of pain may make it impossible for you to do other work in the national economy, while I might be able to do sedentary work. The point here is that the Social Security Administration has to consider your individual differences, your individuality, in determining the nature, severity, extent, and duration of an impairment. There is no average man test, at least in the context of a Social Security case. But I will tell you that's not necessarily the case in an ERISA disability claim. Why would I say that? Well, I think it's important that we develop all of the disabling medical conditions in both cases. We get residual functional capacity forms. But here's an important difference. Sometimes disability carriers will use disability duration guidelines. They'll also use peer-reviewed doctors who don't necessarily believe in some medical conditions like fibromyalgia, or don't believe that these conditions can be disabling or is disabling that would prevent you from doing your own occupation or any occupation. And they will tend to use an average man test. That's one of the reasons why we attack those types of denials in the context of an ERISA disability claim. So while they don't use a average man test in the context of a Social Security case, I do see that disability carriers and plans will use an average person test, an average man test in the context of an ERISA disability claim. So it's important that you understand the differences. Let's take a quick break.